Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now sitting in the Commonwealth of Massachusetts, court is open, please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Sachs and Woods. We'll be the panel on all of our cases today. If you haven't been here, or if you have been here before, each side gets 15 minutes. You needn't use all your time. We do not entertain rebuttal. We have read everything. My best advice is to get right to the point. With that, I'll call our first case, 24P993, Commonwealth versus Rivera. Mr. Hickson.
If I may begin, Your Honor. Good morning, and may it please the court. The defendant had to brief 9 issues in this case, and that would seem unusual, but the number of the charges mandated that, and the errors the defendant has identified required that. That said, I'd like to emphasize arguments 1 and 2 because they reflect on the greatest liability of the defendant. The first issue, and this would be an overarching issue that would apply to all the defendant's convictions involving sexual assault allegations, is the expert testimony of Dr. Stephanie Block. I think that there's several cases that says that her testimony is good, and it's very specific testimony. But I would respectfully submit that her testimony is not good testimony.
Is there any case, Mr. Hickson, that this court, the SJC, has said that Dr. Block's testimony was improper?
Well, in terms of, I do cite one case that said her specific testimony is toward the delayed disclosure is not good testimony and shouldn't be received.
That's what her specialty is, I thought.
Well, it is her specialty, and she may be an expert in that, but that doesn't mean it's evidence, and that doesn't mean it should be submitted as evidence in a court of law in a serious case. Her testimony is simply children evidence disclosure. And I don't know why expert testimony is required, and neither did the court. In the case, I believe it was Dargan, mentioned it. And the reasons are insubstantial. Or actually, they're substantial, but in terms of evidence of an expert, it mentions shame, fear, all those things are well within the jury's comprehension. And even worse, I mean, that delayed disclosure was not an issue in this trial.
I think there's a latent bias against sexual assault victims that they're often not believed because they didn't make prompt disclosures.
Well, I think that was true, but I don't think that's true now.
Did you offer any empirical evidence of that at trial or in the motion to eliminate?
No, there wasn't an objection. There was no objection in the record.
There was a motion to eliminate.
Well, I think she was found qualified, and I mean, I can't dispute that. I don't remember that specifically, Your Honor, I must admit. But in any event,
well, I mean, you say that counsel was ineffective for not objecting, but he did object to the allowance of the motion to eliminate.
Well, if that's the case, and I certainly am wrong, but there's nothing wrong with otherwise arguing that point and seeking to strike it, given its insubstantiality. I think there was a time. And there's a real history in terms of evidence, how evidence has been admitted in sexual assault cases. There was a bias toward children. And if you've lived long enough and practiced long, you realize that it was very difficult because adults were always given the benefit of the doubt in these cases because the doubts were like football coaches and ministers and all that sort of thing, and children were disbelieved. Now I think that that does not occur now.
Wait, but so can we just stick to the case law, the precedent? So I think what you said is that you had one case, I think you're talking about Dunkel, which is a Pennsylvania case.
Yes.
But the closest Massachusetts case, it seemed to me that you cited anyway, was Deloney from this court. But Deloney, I think, merely says that it's within the judge's discretion whether to admit expert testimony on delayed disclosure. So what I'm interested in, do you have, well, first of all, did I characterize that correctly? And second of all, is there a Massachusetts case which adopts your position. I guess that this, okay. So you're asking us to change the law? Is that what you're asking us to do?
Well, I'm asking to apply principles as I understand them. I think the court was in error in the jurisprudence. I think the foreign court that I signed it.
Yeah. Pennsylvania, you mean?
Has a much better take on this, especially on delayed disclosure when it's not in evidence in the case. It's simply basic evidentiary standards. It's prejudicial, but it's not probative. It's not even
at
evidence.
least one of the victims said that she delayed her disclosure because she was afraid of the defendant.
Right, and that's testimony, but why couldn't that testimony be simply credited along with all the other voluminous testimony?
She didn't treat any of the victims, and she didn't indicate, she didn't testify about anything in particular about the victims, right?
No, she didn't, and that her lack of knowledge of the victims, and that's an evidentiary, apparently a prerequisite. But I mean, what happens is when the expert in a case like this has no knowledge of the case, I mean, I would suggest that her testimony really it's much more along the lines of simple punditry. Her words and her teaching would be good for a course to police.
Are you saying that it would have been better if she had treated the victims?
Well, I think there should be some knowledge with the facts, but I mean, I don't think she should have testified at all. I don't think she was a qualified witness. She's
right,
not.
but sorry, but you don't have a case in Massachusetts. I'm just trying to, we have to follow the precedent.
Right.
The precedent, as I understand it, unless you tell me otherwise, in Massachusetts, is that it is within the judge's discretion. Regardless of whether I think that's good or bad, I have to apply the precedent. So it sounds like you're saying, I think you have to say the judge abused his or her discretion. I can't remember.
Well,
go ahead. So is that what you're arguing?
Well, I would say the judge abused her discretion, but I mean, I think my point's a larger one. I mean, it's supposed to be evidence before it comes in. And I mean, I think it's, even to say that it's prejudicial without being probative, that would always be before the court. The court's always supposed to perform a gatekeeping function.
The judge did give careful limiting instructions at the time and then in the final charge, right?
But, yeah, but, you know, expert testimony, when the witness testifies on and on and on about their qualifications, pages and pages and pages about the witness, I mean, limiting instructions are good, but the jury should have never heard the evidence. And once again, I will make a bold...
We have to presume that the jury followed those instructions, including that they needn't credit her just because she's an expert.
Well, I don't think the jury should have heard the evidence. It's not, and I'd even say this, it's not evidence, it's punditry. It really should not be in...
Well, I mean, I read her testimony. I guess I would push back on that. I think that it's pretty fair to say that her course, her study is, among other things, the reasons why kids delay in reporting sexual assault. It's an empirical exercise. She's trying to identify, she and a whole bunch of other professionals in the field are trying to quantify the reasons kids give for delaying disclosure. And so she's trying to, it's not punditry, it's actual science. And it's, that seems plausibly relevant if delay is something that we think could be used improperly to assess credibility. So in other words, what you're saying just doesn't make sense to me. That seems like a more reasonable argument, that it's relevant to credibility. Why is it not relevant to credibility?
Because that form of credibility, delayed disclosure, was not relevant in this case. It's simply, to me, it's very strange. And, you know, I can't say that I viewed the jurisprudence of the court, not this panel, of course, not the appeals court, but I mean to simply say that that children don't, for various reasons, you need expert testimony. And I mean, my response to that is, they're children. Why would a children, what is the child supposed to do? Run to the police, dial 911? I mean, this is well within it, and especially in the year 2020. It's not that way with all the disclosures. And I know that's right on a large canvas. But, you know, when she just simply says, well, fear, shame, disclosure, I mean, it's like taking the thesaurus and writing up the words for negative emotions there. And it has nothing to do with this case, and it wasn't an issue. The defense was, The children made up these stories because he took her telephones away. And that's also in the culture. Telephones, cell phones of adolescents and children is now a big issue out there in our society. And we do operate in a society here, as we did with children testimony through history. And it's just, to simply have, it's simply opining, it's vouching in this, under these circumstances. It's simply, it doesn't have a basis. If there was a delayed disclosure, and there is a recent case, Commonwealth versus Andre, 106 Mass 1, 2025. There was a vast disclosure of time passing from the incident to the investigation to the final reporting to the testimony, and we're talking like 25 years. I think that could be much more relevant, but to simply say, to simply just say there was delayed disclosure in this case. And it's just the way the testimony came out, it was like, well, children do this because of this and this and this and this. I just think that's completely biased. It's simply putting in a whole amount of evidence that was not relevant in trial and just simply say, well, believe the children because children do this. I think it was very prejudicial, and it shouldn't be admitted. This evidence is, once again, I say it's not evidence. I don't think it made anything more probative, or if it did, barely so. It was prejudicial without being probative, and it applies to all the convictions in this case. So I think this is more damaging than the current jurisprudence would admit it, and I think this case is an example of how that can happen. So I think I made my statement on that issue, Your Honor. The medical records. They were not properly redacted. And the court has unfortunately decided that Saint interviews are part of the medical records. In my opinion, no one particularly cares, but they're an investigative. They're a police investigative tool. I've lost on that point, but this shows the problem when it is where the witness will basically say what happened to them. Now that's a hearsay statement, but it's given the benefit of being a medical record, and given in a police guise that there were terrible statements. Once again, they should have.
Can I ask? I think that there was no objection. I think more than no objection. I think the counsel for both sides worked together to go through the medical records, and and so you have to establish a substantial risk of miscarriage of justice, right?
I do believe there's a substantial risk of a miscarriage.
I just want to make sure I got the standard right, of prejudice right.
The standards, admittedly, I am operating under a substantial risk of a miscarriage of justice on all these issues. And that leads to a problem. How can there be no objection? There was no objection to anything, but that's a lawyer's complaint to a large degree. But in this case, what was admitted was very damaging. It's one-sided and has the imprimatur of both medicine and law enforcement on this. Now, I don't blame medicine, and I don't blame...
The notes employed the masculine pronoun he. They did not identify the defendant as having done anything.
No, I don't think the defendant was identified, but the acts were specifically identified. Or, there was more than medicine, let's put it this way. So I think it is prejudicial to him, and they're the only medical records entered. So
the fact of the sexual assault, you say, does not go to medical treatment?
No, sexual assault can, but I mean, it's repeated constantly, and perhaps that should even have been redacted itself. But I don't want to go too far. My target is very specific entries in the record, but I mean, you're completely repeating this the way the records came in.
Then help me out. Which entry do you say created a substantial risk?
Particularly the record in the Sane interview, and I do quote them in my brief. He does it a lot. In the medical record, I don't want to quote my brief, but I mean, he says...
I saw three remarks or three comments that you objected to.
Yeah.
He entered her room. He said, we had to do it, and he put his penis in her vagina. It never says who he is. Those are the three that you object to?
Yeah, those are the three I can find, but I mean, the profusion of the...
Do you think it makes a difference that those comments don't identify the defendant?
No, because there's no doubt who was being talking about. I mean, either the complainants were believed or they were not. And I would say that, that's a whole different form of testimony that allowed that. It should not, those statements should have been redacted. They're prejudicial insofar as they weren't. I mean, it's an ineffective assistance of counsel claim to let those in. But I mean, I can only go so far on a direct appeal with that argument. But I mean, I would say that those were prejudicial when you put it together with the doctor's testimony. I think it is prejudicial. The fact-finding process was.
So if those, I mean, the defense here was essentially they made it up. Is that correct?
Yes.
Would these statements in the SANE report have come in as prior consistent statements if they'd come in on rebuttal or after cross-examination where?
Yeah, I mean, it's possible that they could have. But speculative, I mean, at this point, in rehabilitation or something, I don't know. I couldn't go that far. I was under space limitations, I point out. But I mean, I think that this is the way the evidence came in, and it came in a prejudicial form.
All right, we're going to leave it there. Thank you, your time is up.
Well, I have more arguments, but that's okay, Your Honor.
It's always the way. Ms. Payne.
May it please the Court, Cynthia Payne for the Commonwealth. Commonwealth is asking this Court to affirm 32 of the 33 convictions. Just to touch briefly on the two issues that my brother raised. Dr. Block, this Court has found in numerous times that Dr. Block's testimony is, where the judges found she can testify, there is no abuse of discretion. And the case that my brother referenced, the Commonwealth v. Andre, that was a case in which Dr. Block testified. That was a case in which the court found that Block could testify as to delayed disclosure, which is what we had here, albeit not as long as in the Andre case. And also the fact that in that case, Dr. Block also didn't know the facts of the case, had never treated the victims. And again, the court found that that was immaterial for the point of her testimony. Numerous 23 and 128 cases that this court has found her testimony to be permissible.
I think you'd take the position that Dr. Block not treating the victims avoided the prejudice.
Exactly, exactly. This court has found in certainly other cases, mostly drug cases, that it can be a problem when the person who's an expert has also either treated the victims or has been involved in the case.
Actually, on that point, Dr. Block does testify. I'm looking at transcript, volume 7, page 85. She talks about one of the reasons for false disclosure or delayed disclosure is fear and explicit threats or bribes. And so, for example, that child might be the only child in their house that got a cell phone. Now, I want to be clear. I understand your point that Dr. Block didn't know anything about the facts of this case. I'm not suggesting she did. This seems like just random, unfortunate luck. But that tracks one point in the case where there is an allegation that the defendant was, let me see if I can get it, you know it better than me probably, but broadly threatened to ground one of the victims, to smash her phone, and he would get them to do stuff to get their phones back. Can you talk about that for a second? Is that to be clear, I think it's totally unintentional, but it's unfortunate. Would you agree with that?
I would say that having or taking away cell phones is so common that was certainly a reference that the jury could understand. And the fact that it happened in this case, again, such a common thing. Victims also testified that the defendant in some cases would give money. So, and certainly Dr. Block didn't testify as to anything about that. So the fact that she referenced cell phones, I would suggest, and I know my brother referenced the Deloney case. In that case, the court found that the expert, the way that the expert talked about the profile was too closely aligned.
Right, that's the principle I'm talking about.
But I would suggest that this case is nothing like Deloney, with the exception of the rather off-the-cuff cell phone removal.
Right, Okay.
In regards to the redaction of EC's medical records, I would suggest that the medical records were replete with redactions. There was no reference to assault, sexual assault. There was sexual intercourse and penetration, but I would suggest that certainly that was necessary for the point of that is why the victim EC was brought to the hospital to be examined because of this allegation.
Well, what about the statement, he did it a lot? That seems to me not relevant to treatment, and it seems potentially prejudicial.
I would say he did it a lot, certainly references to, I mean, this is a child who has been being sexually abused, and he did it a lot, could have certainly vast ramifications medically, whether it's a uterine UTI or a sexually transmitted disease. I would suggest that that reference is not error. And even if this court could possibly find it was error, and I would definitely not concede that, I would suggest that it was very cumulative. It was cumulative of EC's testimony.
You agree, though, the smashing of the phones is not medical, really?
Oh, definitely, but I would suggest that that played right into the defense theory that the defendant had a terrible temper and that the girls had made it up, and that, again, played well into the defense theory. And as my brother indicated, this was a direct appeal. Certainly a motion for new trial could have been filed, and that could have been fleshed out. I would suggest that this case was extremely well tried by both the Commonwealth and defense counsel.
Can you remind me, in the closing argument, did defense counsel explicitly reference the fact that the kids were, one motivation for false accusation was the destroying of the phone?
Yes, I believe, in fact, that was the very first sentence of the closing argument.
Right, so I guess that might be a tactical reason to not object. I mean, apparently, and again, correct me if I'm wrong, the parties actually went over the medical records together, and they're going through, we're going to redact this, not redact that. It's not the defense counsel, it's not a case where defense counsel just didn't think about it.
That's exactly correct.
Thought about it, and apparently went through that and said, I'm not going to redact that, and then mentions that, the cell phones. So it seems like this is, if you're going to argue that that was ineffective assistance, you got to have an affidavit explaining explicitly, I didn't do this.
Exactly the Commonwealth's point, Your Honor.
Right.
Again, I would suggest that that played into defense counsel's theory.
Right.
I would like to touch briefly upon the my brother's issue 6, which was open and gross sufficiency argument. I would just like to point out that Commonwealth cited Kessler in its brief, which is good law as to the jury. I would suggest that in Kessler, the jury instructions had been, back at that time, was public exposure. That has changed. The jury instructions itself has changed. It has always been that the conduct need not happen in a public place, but now jury instructions are openly either intended exposure to another or recklessly disregarded. There's no public. I just wanted to point that out to the court, that I should have omitted the word public in my brief, even though that was
It's that element is set out in the disjunctive, right?
correct.
Can I just, I want to go back to the medical records for a second. I'm trying to work through, you made this argument in passing that if there was any error in any of the statements coming in, it was cumulative. And the problem, I think, to the extent there is a problem, is corroboration. Corroboration is obviously, credibility is central here. That's the defense. She's lying, or they're lying. What's your response to, is corroboration, relevant, is cumulative, an argument that this is cumulative relevant to corroboration? That's what I'm sorry to not be as articulate as I should have been.
I suppose it could be, and perhaps Commonwealth, certainly, I could have just stayed with, this was not improper. And even if it was, there were limiting instructions, very well crafted limiting instructions here. both immediately following the testimony and during final instructions. Again, very, very thoughtful. They were crafted by, I would suggest, the Assistant District Attorney, but it was also in agreement with Defense Counsel. Again, this was a very, very well-tried case by both parties. The trauma imposed on the 3 child victims, incalculable. The carnage that this defendant wreaked on their lives, Commonwealth would ask that you affirm the judgments of conviction in the 32 of the 33 cases.
Just one housekeeping matter. On the indictment for the attempted assault and battery, there's
Yes.
no overt act, and you concede properly that it doesn't allege a crime. Do we need to send it back for resentencing, or is that a concurrent sentence?
Well, it was a 2.5 years to the House of Correction. Defendant was sentenced on 10 counts of life with the possibility of parole at 20 years. I would suggest that 2.5 years concurrent to the House of Correction.
He has another House of Correction sentence, right?
Yes, that's
So
correct.
just
On the assault and battery charges.
vacation?
Yes, Your Honor.
Thank you.
Unless the court has any further comments.
None. Thank you both.
Thank you so much.
Our next case, excuse me, is 25P1216 Commonwealth versus Martinez. Mr. Sullivan.
Good morning, Your Honors. May I proceed?
Yes.
May it please the Court, I'm Ryan Sullivan. I represent Mr. Martinez. I want to start by saying that these 3 issues are all intertwined as they go to the what I would say is the sole contested issue in this case, which is the intent and knowledge of Mr. Martinez as it related to the assault and battery with a dangerous weapon. Starting first with the denials that were admitted. I think it's clear error here. And one of the reasons I say that it's clear error is that the defense in limine was arguing that the denials should not be admitted because of the concerns in Diaz. And the judge's argument in admitting these or his reasoning in admitting the denials was the exact issue that Diaz prohibits, that it eviscerates the rule that regarding the presumption of innocence, if a defendant has an accusatory statement, he denies it, and that is used against him because the government presumes that
In Diaz, was he accused of committing the crime and he denied that?
So that is an excellent point that ADA Walsh brings up in her brief, that there is a distinction between Diaz and Rivera in how the statements were admitted to them. I think the reason that the government doesn't win on that point, though, is that Rivera had a different standard of review, where here this was a preserved error, and it's the exact same issue. And so I don't think the court—
But we were reviewing for an abuse of discretion.
Yes. But what I would say is that the reason it's abuse of discretion is because this is the prohibited issue. You can't say, were you at the location? I don't know what you're talking about. We're saying you were at the location. That's saying you can admit this because the trial judge made an argument that he did what he's accused of. He was at the crime scene. And it just, that circular logic is why Diaz says you can't have these statements.
Wait, can you back up? So in Womack and Diaz, the rule requires an accusatory statement. And are you claiming that there was an accusatory statement? I've got the transcript right here. You give it to us in your brief. If you're saying, well, are you saying there's an accusatory statement?
I think it's an accusatory statement because it's
In which question? Just quote it.
about wanting to be at the location. So that's the problem I have is that this is more like a Rhode Island versus Ennis issue. It's the functional equivalent of a accusatory statement, saying, were you the person at the crime scene? He denies it. Now, I think everyone here considering this knows that he was lying when he denied it. But to admit that says that if you are asserting your right to be presumed innocent, that can be used against you as consciousness of guilt. That is not the rule, and it should never be the rule. There was plenty of other consciousness of guilt evidence that was properly admitted. Jumping out the window and running away when the police were going to arrest Ms. Drew, that's a really good point that the government was able to elicit. Saying, no, I am objecting to you accusing me of committing this crime when we're talking during the interrogation is not a factor that should be used against.
Does it make a difference that he admitted in his closing and elsewhere that he was at the location? So right from the get-go, we know it's a false statement.
Well, but the problem is that we know it's a false statement because trial counsel, faced with an overwhelming amount of evidence that he was at the scene, embraced it. But I still don't believe that it can be overlooked that a denial of being present at the scene cannot be used as evidence. And one of the issues that I have is, although I wish I didn't have to agree, that the jury is presumed to follow the limiting instructions, in this case, it's like trying to unring a bell by ringing it again and then instructing the jury, don't listen to the reverberations. And so when they're told, you can consider Mr. Martinez lying about whether he was there as evidence of his consciousness of guilt, it is incredibly prejudicial here because Mr. Martinez is saying in his trial strategy, I was there, but I didn't know that it was police officers who were attacking me and jumping me. And so if the more instances where the jury heard, this can be considered as consciousness of guilt evidence, it goes directly to his
But it was of his own making, though.
I'm sorry, Your Honor?
It was of his own making. When the police spoke to him, he was not obligated to speak to them. But once he does and lies to them, then it evinces consciousness of guilt.
So if he were to build, so I would say if he's lying to them in the terms of building his own narrative, and those are great examples of where I do think those
Well, I think he built the narrative later. At that point in time, he's trying to exculpate himself.
Correct. And that decision to try to exculpate himself should not be used against him in his trial.
Can I ask, do you have a case in which there's not an accusatory statement? Your definition here of, we all know that this was an accusatory statement. In Womack, it was absolutely an accusatory statement. You did the crime. And I don't actually know if in Diaz it was, but in response to police accusations is the quote that you've given us. Do you have a case where this kind of, I don't actually think it's you haven't convinced me that this is an accusation. Do you have a case?
I would like to say that Eduardo Martinez would be a great case for future defense.
Nice.
I do not have a case under these specific issues, and I agree that it is a narrow issue. And if it was the only ground that I had, and there weren't these other issues,
I understand the evidentiary difference, though, because the denial of the accusation of the crime is hearsay, whereas the lie to the police is not coming in for the truth of the matter asserted. It's coming in to show consciousness of guilt.
But and because it's coming in for a consciousness of guilt purpose, and I absolutely agree with Your Honor, but it doesn't take away whether or not its probative value is outweighed by its prejudicial effect. Its prejudicial effect is saying, by saying, I'm not agreeing with you that I committed the crime.
Was that raised in front of the judge?
I think by the trial counsel arguing Diaz and Womack, it precisely was. The judge disagreed, saying, the judge mentioned he's had many different cases where the denials have been inadmissible, and then ruled the opposite way in this case. And I think this was a central issue here. And again, there was other evidence of consciousness of guilt, and so I don't see how the probative value here was outweighed. And I think this dovetails into the same reason that I think severance should have been ordered in this case. Because although I agree, again, with Ms. Walsh, it's difficult having such a worthy adversary, that from a 30,000-foot view, the two embrace the self-defense argument together. But Ms. Drew's argument was, I should be exculpated because he is the person who is the bad actor. That is directly the issue about having antagonistic defenses. Mr. Martinez did not have an antagonistic defense towards Ms. Drew, but she absolutely had an
Drew's
antagonistic.
defense attorney didn't put that spin on it in closing, though, did he or she? Right?
I do believe that Attorney Christian's saying, that this is, I agree with his colloquial, I don't have much to
No,
add
because
here.
we agree with what the defendant argued in closing.
I'm sorry?
We agree with what the defendant argued in closing. I don't have much to add to that.
But then he juxtaposes Mr. Martinez's consciousness of guilt evidence with what he would characterize as Ms. Drew's consciousness of innocence. And that's the issue. Right. My client didn't run. My client called the police. My client was cooperative. We know that Mr. Martinez was none of those three things because he's saying that when the issue here is intent, he's saying my client did not have the intent. I agree with what counsel's saying is that this was an argument of self-defense. I'm sorry, I'm using too many pronouns. Trial counsel for Ms. Drew agreed with trial counsel for Mr. Martinez that, yes, this is self-defense, and then said, on top of that, here's the reasons why Mr. Martinez is the bad actor, and then when we get the...
Does counsel argue that as opposed to just talking about Drew?
I think his argument is precise. So in closing, he doesn't point the finger to Mr. Martinez. I agree with the court. His points necessarily juxtapose Mr. Martinez in that bad light. And I think his cross-examination questions, you weren't looking for Felicia. You didn't have Felicia in the reports. You didn't know Felicia. Juxtaposes that the police...
She made the phone call, right, to report the car stolen?
Yes.
But she never appears in person to make the complaint that as she was instructed.
Correct. I'm not sure why the Commonwealth didn't argue that that phone call was an exculpatory intent to, or an attempt to...
Or her not reporting it in person would indicate that she has consciousness of guilt. Yes.
I don't know why that point wasn't fleshed out more, but I think it's because this was about Mr. Martinez much more than Ms. Drew. She was a sideshow in Mr. Martinez's trial, which is why I don't think she should have been there, because these points saying, look at my consciousness of innocence, negatively impacts Mr. Martinez's trial defense.
I'm struggling with that because I think that her lawyer's point was, as you said, intent. When I see the police coming to me afterwards, when I know it's police, then I behave differently. So you can contrast that to how I behaved. I clearly understood these people to be, or at least it's a reasonable doubt whether I understood these people to be police. That's the point. But that's not blaming him. Here's why I'm innocent. That's not mutually inconsistent with he's guilty. And also, your bigger problem is there's tons of evidence that they're guilty as joint venturers. That the direct testimony that she's turning the key in the ignition and putting it into drive while he's putting the gas pedal down. If there's evidence of joint venture, then it's not a basis for severance.
So I would say that the issue here is that there was more than just those arguments regarding her intent. His cross-examination, I believe it was of Detective Osler, about the physical impossibility of shifting the car into drive without pressing the brake, and that Mr. Martinez would have had to necessarily press the brake in order to cause the car to shift. Therefore, he is the person, essentially her point is, we had to act in concert together. She's saying he knew, he was part of this. I just see this, it sounds like the court doesn't, but I just see this very clearly as, that she was pointing the finger at him. That was her path to acquittal.
She drew. His co-defendant was pointing the finger at him. That's your point.
If Rule 9D required the defenses to be identical or severed, I could understand what you're saying, but it doesn't say that. They have to be antagonistic, mutually exclusive. And saying we both are arguing self-defense, we both didn't believe they were the police, we both thought we're in trouble as drug dealers in this violent, high-crime neighborhood. And by the way, I cooperated. That's not mutually exclusive as far as I'm concerned.
I think her saying, and that's why I say that I don't believe Mr. Martinez was antagonistic towards her, but I think her path to victory has to say, I did not have the intent to do this. And that's, I think,
But she doesn't do that.
I would say she very subtly does, which is why the two of them should have been separate.
Is there a transcript site where you can give us evidence of this?
I think it's as I raise in my brief, the juxtaposition that Attorney Christian artfully makes in his closing is what is that subtle nod. But I agree with you that it's not as stark as I would prefer it to be. Lastly, I just want to point out, and it seems like I'm giving her too much praise, I also agree with ADA Walsh that unfortunately, in using the fentanyl sale, that the court may determine that if any error in its admission, the adoption of that as one of the bases for asking for self-defense may not require that being an error that would require reversal. The reason I bring that out is, one, I think that the strategic decision to do that was after the judge had already issued the order that the warrant would be admitted, and so the defense has to explain away something other than the warrant.
The warrant was objected to, but the drug ruse
Yes.
bit was not.
I'm not sure why, and being on direct appeal.
And they used it.
Yes, and they used it, and they got a self-defense instruction. But I do think with the admission of the ruse, which, by the way, not to cut too fine a point, but I mean, I think fentanyl could have been taken out of it. I think, that we knew that there was a drug transaction or something that's take place that could have lessened the prejudice. But in any event, it was used. Strengthens my argument that the warrant was improperly issued. Especially, I think, Limon is my best case here, where the warrant wasn't communicated, the existence of the warrant wasn't communicated to Mr. Martinez.
Isn't it an element of resisting arrest that the officer had to be acting under the color of official authority?
And so, yes, but because it wasn't communicated to Mr. Martinez.
Well, that's a different element, whether he had knowledge that he was being arrested. So just because they didn't say we have a warrant, we're the police, doesn't take away the need for the Commonwealth to prove that they were acting under color of official authority. And how else did they do that except saying there's a warrant?
Well, they could say that they had probable cause to believe that he had committed a conspiracy to violate the drug laws by engaging in this fentanyl ruse sale, and therefore that was a different basis in which to do so. It's that the warrant itself paints.
So you're saying that the warrant evidence didn't need to come in because the drug ruse evidence was there anyway?
Correct.
Well, that seems like, I mean, I've heard of arguing in the alternative, but you can't win on both of those.
So, and that's precisely my point in bringing it up, that I agree. I wish I could win, and I'm happy to win on both of them. But if the court is going to find that one of them is error, I think it's the warrant.
Are you good? Yeah. Thank you.
Thank you.
Ms. Walsh.
Good morning. May it please the court. Emily Walsh for the Commonwealth. Justice Hagan properly denied the motion to sever, where both defendants raised the same defense. Both the defendant and Ms. Drew presented the defense that they believed they were being attacked and did not realize the individuals coming towards them were police officers. The defendant, through counsel, claimed that he was terrified and did not realize that the officers were police, and that he was running for his life. Ms. Drew, via counsel, argued that she did not know these were police officers that they encountered at the car wash that night, and Ms. Drew's counsel addressed the call to the police department as that of a frightened person who's still trying to process, who's trying to figure out who those men at the car wash were. That's what the call is. Further, as discussed, Ms. Drew's counsel adopted the defendant's arguments. Rather than incriminating the defendant, Ms. Drew's counsel stated after the defendant's closing, "I don't have a whole lot I need to add to that very comprehensive presentation" by defense counsel. Further, Ms. Drew's counsel adopted the directed verdicts made by the defendant's counsel, and Ms. Drew's counsel did not cross-examine most of the witnesses. There was no error in denying the motion to sever. There was also no error in admission of evidence related to the defendant's arrest, warrant, or evidence describing the the ruse drug transaction. Regarding the arrest warrant, as discussed, the defendant was charged with resisting arrest, and the existence of an arrest warrant is therefore highly relevant to that element of proof. No details about the outstanding warrant were admitted, and there was a limiting instruction regarding the arrest warrant, which was given contemporaneously, and again in final instructions. With regard to the drug ruse, it was not objected to, but rather was relied on heavily during the defense case to argue that the high crime nature of the drug business and of drug transactions meant that the defendant was acting in reasonable self-defense.
What about the denial of him being at the car wash?
The denial of him being at the car wash was not a direct accusation, as was the case in Womack, where the interviewer said, "You robbed the place, you stabbed the clerk," or in Rivera, where the interviewer said that to the defendant, to the interview subject, "You have been identified as killing this kid." In contrast here, he is asked where he was. And not only did he...
That was Diaz?
He says...
Killing this kid. The quote you just gave, that was from Diaz?
From Rivera.
Oh, sorry.
Rivera, it said, "You have been identified as killing this kid." Okay. So that is a direct accusation.
In Diaz, the SJC at least implied that a couple of comments or accusations were improperly admitted. One of them was that the defendant was not in Lowell on the date of the incident, and that he had not been driving a Mitsubishi.
So I don't have the...
Different from...
I think that there are two reasons why that is distinguishable. Well, one, Diaz was overruled in part by Womack. So I don't have the case in front of me because it was overruled. I understand that there are legal points that stand, but in this case, not only did he deny it, he gave a false narrative. He said he was at home. So it was not a direct accusation, and my brother's argument that it is the functional equivalent, your presence there, is not consistent with Rivera and Womack. Instead of being faced with a straight accusation and a straight denial, he was asked a question and he gave a misleading or false answer. He did not just say, "I wasn't there." He said, "I was at home." I believe he also said he had a barbecue that night.
If they said, "Were you at the car wash?" and he said no, then that would not have been admissible?
I think it would be closer, but I am not saying, I think it would be closer. It's still not a direct accusation, but it's closer. Whereas here, not only was it not a direct accusation, he didn't just say no, he gave false information, and it is well established that defendant's statements are admissible against him.
What aspect of Womack would suggest that the treatment of these accusations in Diaz as potentially inadmissible accusations is no longer good law?
Again, I'm sorry, I don't have Diaz in front of me to give you a more complete answer, but I believe it was the standard of review that was actually overruled from Diaz in Womack, but my memory of Diaz was that there was no further statements, that it wasn't these misleading, incorrect statements. He gave a false explanation of his whereabouts on that night. He said that he was home, which is outside the realm of the hearsay rule that a direct accusation and a denial. This is not a direct accusation and a denial. It's a question about a whereabouts and a false answer.
What about the question to the defendant here? Do you have any idea how the Lincoln got to the car wash?
I think that's even farther from a direct accusation. That's a question about knowledge, and he said he didn't know. That's not a direct accusation. I think that is outside the scope of the rule and goes towards just defendant's answers or statements by the defendants are admissible.
And that fact that in Diaz, the denial that the defendant was driving a Mitsubishi is different from the defendant didn't know how.
I think it's also more broad. How did they get there is different than were you driving it? It's not even, the question was, he was asked how the car might have gotten to the car wash that night. It's not an accusation. It's not even a yes or no question. He was asked about the car and its whereabouts, and he denied knowledge. Are there any further questions about the admissions of the defendant?
I'm struggling to articulate it clearly, but the sequence, the defense again embraced the ultimate position that he was at the car wash, which then made these denials consciousness of guilt evidence. And your opponent says, well, he was sort of forced to do that because of this conversation. I'm wondering, sequence-wise, if the sequence matters at trial. In other words, if obviously this officer testified about this before the defense proceeded. In opening statement, did the defense, and I don't know if this matters, but if did the defense mention this defense in opening statements?
The defendant at opening did not, yes, he did not, he essentially conceded he was there, but it was resolved at a motion in limine, and a motion in limine hearing on May 18th, 2023. This was addressed, so the counsel knew that.
Okay, so it was clear at that point. Okay, yes. Right, thank you, that's
and the judge at the motion in limine hearing said this is not a straight denial. These are statements that go to consciousness of guilt.
Okay, so theoretically, all right, thank you for acknowledging that. So I guess theoretically, right, that's the right question, maybe, and I bet your opponent briefed it this way. but the motion in limine, once that ruling has been made, defense counsel has to make a choice, and the choice he or she made was, okay, well, we're going to embrace this. But theoretically, if that motion in limine ruling was error, then and we reject your view that these are not sufficiently accusatory, then that could be, the embracing of it is not relevant anymore.
The defendant certainly made strategic decisions based on the decision in the motion in limine.
Right, okay, but yeah, thank you.
Are there any further questions?
No. None. Thank you.
Thank you.
Thank you both.
Thank you.
Our next case is 25P818, Edward McCarthy versus Trenton Andrews. Splitting your time. Thank you. Mr. Doonan?
Good morning, Your Honors. Or good afternoon, I'm not quite sure. Good morning. May it please the Court, Robert Doonan on behalf of the plaintiff appellant, Edward McCarthy. I would like to focus on three issues central to the Rule 12C dismissal. First, the dismissal depended upon resolving disputed factual issues against the plaintiff at the pleading stage. Second, the amended complaint expressly disputed scope of employment and pleaded alternative scope theories. Third, the amended complaint alleged separate negligent police cruiser operation claim, not merely a roadway conditions, so to speak, claim. Your Honor, I would submit that the findings by the court, they decided disputed factual inferences and disputed facts improperly pursuant to 12C. The amended complaint alleged a lot of facts, including that Officer Winooski was operating a vehicle at approximately 41 miles per hour in a 30-mile-per-hour zone. I would state that that is not insignificant in the sense that it equates.
It wasn't just any vehicle, it was his police cruiser.
Excuse me?
It was his police cruiser.
It was.
That's how it's pled.
It was.
Yeah.
He was driving a police cruiser, no doubt about that. He was driving it, but what I was saying is he was driving at 41 in a 30 mile per hour zone, which equates out to approximately 90 in a 65 mile per hour zone.
So the Doyle case that both parties have cited, I think, says the Tort Claims Act applies to negligence, gross negligence, and recklessness. So regardless of how fast he was driving, unless you're alleging an intentional tort, which you're not, then if he was within the scope, he's protected, and it's the town that's liable.
I agree with you 100%.
So why does how fast he's driving really make a difference here for us?
No, I would say that it's one of the factors which comes into whether or not he was within the scope of his employment. I'm not saying he was or he wasn't working. counsel has repeatedly indicated that he was working, and I acknowledge that.
You admitted at the hearing that he was on duty.
Yes, based upon, I acknowledge what he represented. I have not had a
Are
chance.
you not bound by that?
I think an assertion of counsel at the hearing does not bind you at,
Sometimes it's called a judicial admission.
well, I would respectfully submit that what is said in the hearing is an assertion. It is what is said in the complaint itself, the facts alleged in the
Well, I
complaint.
mean, you don't get to hold your fingers behind your back, right?
No, but I understand what you're saying.
The court is entitled to rely on representations by counsel who are bound by ethical principles to be candid to a tribunal.
I hear what you're saying, Your Honor, and I understand that. But what it comes down to is whether he was working is not relevant. Working does not equal scope of employment. The fact that he was working, like the Berry case explicitly said, you can have tortious acts within the scope and tortious acts outside the scope.
Yeah, but the allegation in the complaint is that he's driving his police cruiser, and you say excessively so, which contributed to the accident.
Correct.
And he's on duty in a police cruiser. It's not like he's in Chatham Harbor shooting seals with a shotgun while he's on duty.
No, Your Honor, but I mean, the fact of the matter is, pursuant to 89.7B, police officers have a duty to drive within the speed limit, and I would submit that this was excessive. It's not just that.
This goes to what Justice Sachs pointed out, that doesn't take him outside the scope of the Tort Claims Act.
But I think if you look at everything, including the operational justification, the fact that he knew that that intersection was extremely dangerous, he knew there was no stop sign, he was on the road for approximately 500 feet, he had accelerated up to 41 miles per hour.
Do you have a case that establishes, so all of that goes to negligence, gross negligence, lack of his breach of duty of care, but that's not the question of scope. The question of scope, it sounds like if you're required to, Justice Meade's point, if you're required to concede, because you did, that he was on duty, is there a case that says what you're arguing, that on duty outside the scope?
Yes, the Berry case specifically has that. The Klickner case specifically has that.
Okay.
Those two cases indicate that both were working, and what they were doing at the time was outside the scope. And that's what the court ruled.
Is scope something that needs to be affirmatively pled, or is it a defense?
It was affirmatively pled in this case, the amended complaint.
No, but I mean, just saying he was outside the scope, I wouldn't say that's well pled. That's just a conclusion.
Right.
Is the burden on the plaintiff to establish that a defendant in this situation, a public employee, is acting outside the scope, or is it the burden on the employee to establish, no, I was within the scope, so I'm immune, and my employer is liable?
I say it's on behalf of the plaintiff to prove that he was either working within the scope or outside the scope. And it's on the defense side, one side being on behalf of the attorney, on behalf of the police officers, argued that he was within the scope, and the town to say he was not within the scope. And that's what we have, defense counsel arguing for both, having different arguments. In the complaint, I indicated, in addition to 41 miles per hour, we alleged that he knew the intersection was dangerous, visibility was obstructed, there was no stop sign. He braked 0.4 seconds before impact. I also specifically stated in the amended complaint, he was not following any car or otherwise performing any duty which would have required him to speed in that way. I further alleged he misused the police cruiser, unlawful speeding, egregious failure to slow down, and conduct inconsistent with his duties. I would respectfully submit that all those facts certainly leave a question where the fact finder could determine that he was acting outside the scope of his employment.
Okay, thank you. Mr. Brosnan.
Good morning. May it please the court, John Brosnan on behalf of Trenton Andrews and Stephen Andrews. I'd like to start with the court's dismissal of the respondeat superior claim, count 4, because what the motion judge ignored in this case is that in the amended complaint, the plaintiff asserted 2 separate claims against the town. One was based under, what she concluded fell under the road defect statute, and the other one was just a straight Mass Torts Claim Act under General Law, Chapter 258, Section 2.
Count 4 is the respondeat superior, count 7 is the road defect act, right?
Exactly. So I don't know how the judge came to the conclusion that the respondeat superior count was broomed out. And in fact, there was a lot of inconsistencies in her rationale, and I think it was a one-sentence statement, and for the reasons cited above, the road defect bars the respondeat superior count. We cited 2, the closest cases we found were 2 Superior Court cases. One was decided by Judge Dorfer, the Benedetto case. The other one was decided by Justice Curran in Santo. And at page 32 of my brief, we discuss the De Benedetto case. And in there, they came up with a rule that the cases decided under these road defect statutes, there's both a state and a municipality one, have involved immobile objects that render the public way unsafe or inconvenient for ordinary travel. On top of that, the court said there's no indication in the road defect statute that the legislator intended to deprive a plaintiff of his or her right of action against a Commonwealth employee who negligently operates a motor vehicle on a state highway and thereby causes injury. The counsel for the town and Officer Wisniewski has not cited any case law to support its position. In Stewart versus Brookline is the SJC case. It makes clear that a police officer has a duty to operate a vehicle so as not to endanger other motorists. I think the gist of the plaintiff's claims against the town and Officer Wisniewski is that he was operating the cruiser in a negligent manner.
What's your view of who has the pleading burden on issues of immunity? Is it up to the plaintiff to plead that the public employee is outside of the scope, or is it up to the public employee to plead that the employee was within the scope and therefore the public employer is liable?
It's an affirmative defense. It's an immunity. So we cited some case law in the brief on that point. So it'd be like, it's like the 10J. They have another argument on 10J. So I'd say it's similar to that they carry the ball.
I saw the citations to the Pinshaw and the Berry cases, but I couldn't find anything in those cases that spoke to who had the burden or whether it was an affirmative defense.
Yeah, I didn't find that. I think in the reply brief that I cited, Your Honor, I think I may have cited some cases. Yeah, on page 7 of my reply brief, it's an affirmative defense. I cited Lopes versus Riendo, 177 F sub 3rd, 634, 2016 case, quoting a Superior Court case, Tamaccio versus Hardy. And then I have a quote in there from Tamaccio: defendant public employees bore the underlying burden of proof on the issue of entitlement to immunity of a public employee. Yeah, so I think there was clear error in dismissing count 4. And I'd now like to go back to the claim against Officer Winooski. I think you raised a question about Doyle, Justice Sachs, but I think you got to look at Berry, because Berry's the SJC, and that's the controlling case. And in that case, they said unsafe driving that has no purpose, it's not motivated to serve the employer's purpose, that is not protected. That's not within the scope. So you get into the continuum. They're focusing on what happened there, where the guy was doing donuts and slid into the picnic table and injured another officer at the shooting range. But you get into the continuum with what's gross negligence, which gets back to my principal point, is that the motion judge jumped the gun. Under Pinshaw, this is an issue, it's an issue of fact. There's the three-pronged test of the scope of employment is something that's, has to be decided at the earliest, I would say, the summary judgment stage. There's the Pettiford case, Justice Englander ruled on recently. That was the Dunkin' Donuts employee that insulted a restaurant patron and hurled a racial epithet at them. He specifically stated, you cannot decide what the motivation of this person was at the pleading stage. So I think there's a long line of cases. I've cited several of them in my brief, but I think Pinshaw really pins that down. And on the affirmative defense on 10J, originally caused simply means materially contributed to the condition that caused the harm. It's not the sole cause.
It has to be an affirmative act, though, not just the failure.
But this is a 3-car accident. First impact is Officer Wisniewski striking.
What do you allege caused the accident?
Officer Wisniewski was speeding. If he was not exceeding the speed limit, he didn't brake till 0.4 seconds before he struck Mr. Andrews, the vehicle Mr. Andrews was operating. So the two of them, that created a force, a very strong delta V force that pushed both vehicles into the
And that was caused by the defective intersection.
It had nothing to do with the defective intersection because Officer Winooski had nothing to do with it. He's a police officer. He's in his cruiser.
I thought there was an allegation that the failure to
There's two separate theories.
Excuse me, to install reinstall the stop sign and cut back on the foliage at the intersection and the fence.
Yeah, in the amended complaint, there's two separate theories. One is there's the defect, lack of stop sign, excess foliage, blocking of sight lines, and secondarily, it's the conduct, the independent and distinct conduct of Officer Wisniewski in driving at an excessive rate, failing to brake, and striking. So,
Do you have anything else? Yeah. Okay, thank you.
Thank you very much, Your Honor.
Mr. Fahrenkopp.
Good morning, Your Honors. Cole Fahrenkoff for the town of Chatham and Officer Joshua Wisniewski. Justice Sachs, if I may start by addressing your question about the pleading standard for immunities. In Doyle, this court said that it was the plaintiff's burden to plead facts sufficient to establish that the officers were acting.
Does that make sense to you?
Yes, Your Honor, it does. Typically with immunities, once they are raised, it becomes the plaintiff's burden to rebut those immunities. That is because they're not immunities from liability, they're immunities from suit.
So who has more access to information about whether Officer Wisniewski was in the scope? Is that something that the plaintiff has to allege facts that affirmatively disprove?
Yes, Your Honor. The plaintiff's burden is to plead facts sufficient to plausibly suggest that the officer was acting outside of the scope of his employment.
But how can he know what the officer's doing in his cruiser, whether he's on duty, whether he was responding to an emergency call somewhere? Isn't that much more information in the possession of the officer himself and the town?
Well, Your Honor, certainly the plaintiff can make a public records request prior to filing a complaint. to establish whether the officer was in fact acting within the scope of his
So in
employment.
essence, he has to do some discovery in order to figure out who to sue.
Not necessarily, Your Honor. Here, Officer Wisniewski was in his uniform in a police cruiser on a town-owned roadway.
Where do we hear that he's in his uniform?
Your Honor, I apologize if that was not in the record. However, as Justice Meade noted at the arguments on the motion for judgment on the pleadings, counsel for the plaintiff acknowledged that Officer Wisniewski was in fact on duty.
How do you distinguish this from Berry? I went back, thanks to your opponent, and read their brief, and I was reminded that that is a police officer, just like this case, on a paid lunch break, which I guess makes it clear that he's on duty, and broadly alleged to be driving very recklessly. Nothing in the dangerous game of driving too fast toward the picnic table behind the storage container where the officers were present, slamming on his brakes, furthered the interests of the town. SJC holds, as alleged, he's outside the scope, even though he's on his paid lunch break. So it sounds like they're saying that's outside the scope, even though he's on duty.
Well, Your Honor, in Berry, absolutely no inference could be drawn that the officer's conduct was in furtherance, or I'm sorry, was motivated by any goal to further his employer's interests.
But your opponent's point is driving too fast. It seems to me that there's a spectrum here. I take your point that, okay, in this case, the facts alleged, it seems much less negligent than the facts alleged in Berry, but it arguably could be, and isn't that a question of fact to be resolved at a later stage?
No, Your Honor, because on the facts pled by the plaintiff in this case, this court may conclude that Officer Wisniewski was acting within the scope of his employment.
Why?
To Justice Meade's point earlier, it's not as if the plaintiff pled that Officer Wisniewski was shooting seals in the harbor. Conduct that would be...
Sure, that would be really, really negligent, and he also wasn't doing donuts near the picnic table, which would be worse. But is there a case that says speeding is not negligent enough?
Well, Your Honor, we cite to a First Circuit case, McIntyre, in our brief that stands for the proposition that an FBI informant who an FBI agent who leaked information on a confidential informant resulting in harm to the confidential informant did not fall outside the scope of employment. So there, even where you have a violation of the law, the agent was still within the scope of his employment.
Okay, but that doesn't seem very analogous. Berry, is there a violation of the law in Berry? He's just driving, the officer's alleged to be driving grossly negligently, I guess, but I don't think he's being alleged to. The key is not whether he committed a crime or didn't commit a crime. In other words, McIntyre doesn't seem analogous. Berry seems really analogous, but just a little bit more negligent.
Well, Your Honor, Berry goes far beyond the bounds of the facts in this case. The officer there was on a break from training, was doing donuts in the parking lot.
Wait, break from training. Is he on duty? It sounds like he's on duty.
Your Honor, he was on a paid break from a training.
What does that mean? He's on a paid break? I don't know what that means. He's on duty, I think. He's getting paid, so I think he's on duty?
Well, Your Honor, at the time that he's on a break, I don't think his conduct was in furtherance of his employer's interests.
Okay, but he's on duty, and he's alleged to be behaving negligently. So it sounds like those two things are the same as this case. On duty, as far as we know, and speeding, which seems to be negligent. I'm struggling to understand why those are different.
Your Honor, in Berry, the officer went well beyond the bounds of negligence. He was doing donuts in a gravel parking lot. He came to a stop, and then he accelerated directly at the plaintiff and failed to stop.
Okay.
He was, in essence, driving a car intentionally directly at the plaintiff in that case.
Okay, thank you.
Thank you, Your Honor.
Could you address how the failure of the road defect claim can insulate the town from liability for the officer's allegedly negligent driving under the Mass Tort Claims Act?
Well, Justice Sachs, ultimately, at the end of the day, the plaintiff is the master of his own complaint. As this complaint is pled, the cause of the collision between the three parties was the absence of a stop sign at the intersection and the overgrown foliage.
He doesn't plead that that's the only cause, does he?
No, Your Honor, but there's no...
He pleads that the negligence of the officer is one of the causes.
He does make that conclusory allegation, Your Honor. However, there's no allegation anywhere in the complaint that this accident would have occurred if there had been a stop sign and the foliage had been cut. In fact, the complaint reads to the contrary. The plaintiff, pardon me, Your Honor.
Go ahead.
The plaintiff acknowledges that this accident would not have occurred if there was a stop sign or the foliage had been cut back.
Where does the plaintiff do that? And is that pleading in the alternative? I mean, if the plaintiff asserts that the negligence of the officer was one of the causes, then why doesn't that claim survive, even if the cause attributed to the lack of stop sign and failure to trim branches falls out of the case because there was no notice?
Well, Your Honor, if there was no roadway defect claim and there had been a stop sign, no overgrown foliage, and this was a Chapter 258 case, the town would still be immune under Section 10J.
Oh, okay, but you're shifting to a different issue now. What I'm focused on is why the failure of the road defect claim should negate the town's liability under the Tort Claims Act. And well, go ahead.
Thank you, Your Honor. In Record Appendix, page 318, the first amended complaint, a quote, if a stop sign had been erected, Andrews would have stopped, preventing the August 11th, 2020 accident. There are similar allegations in the complaint about the overgrown foliage. So here, ultimately, plaintiff has pled that this accident was caused by the absence of a stop sign and the alleged failure of the town to cut overgrown foliage as well as enforce a mandate that...
But that's a part of the claim against the Macklins for, I guess, not maintaining their... well, I don't know why it's a part of the claim against the Macklins, because it's about erecting a stop sign, which they don't have the authority to do. But I don't understand why the plaintiff can't plead in the alternative here. If there'd been a stop sign, this wouldn't have happened. If the officer hadn't been driving negligently, this wouldn't have happened.
Your Honor, because ultimately that's nothing more than artful pleading. At the heart of this case, the plaintiff alleges that if there had been a stop sign or the foliage had been cut back, there would not have been an accident.
Well, but at RA 314, paragraph 48, as a direct, and this is count 4, the one that we're actually talking about, as a direct and proximate result of the negligence and carelessness of the town's agent and employee Wisniewski, the plaintiff was caused to sustain severe injuries. In other words, it's alleged properly there, and it doesn't say anything about why isn't that enough?
Your Honor, that's not enough because elsewhere in the complaint, the plaintiff makes clear that this all stems from, or he believes that this all stems from the missing stop sign.
So with regard to 10J, what is the, how does Officer Wisniewski's driving merely fail to prevent or diminish the consequences of the accident versus being one of the original causes and making it worse by pushing the Andrews car, I guess, over into the lane where the plaintiff was oncoming?
Well, Justice Sachs, Officer Wisniewski is not the original cause because this complaint lacks any allegation that this accident would not have happened but for the conduct of the Andrews defendant. In other words, it was not Officer Wisniewski's conduct that caused this accident. It was the Andrews defendant's, Mr. Andrews' failure to stop
He made it, even if he didn't cause it in the sense that it might have happened, that the stop sign was one of the original causes, he certainly made it worse. At least it's alleged that he made it worse because he was driving so fast and he pushed the Andrews vehicle into the oncoming lane.
Well, Your Honor, the SJC has cautioned against reading original cause to be so broad as to encompass anything that may have potentially caused the accident or the harm that the plaintiff complains of.
Isn't it, if it's sufficiently pled that it's a combination of two factors, Wisniewski speeding on a country lane and Andrews blowing through what he was an intersection with or without the stop sign where he should have stopped, and they both are behaving negligently, and they, in combination, crash and cause the damages to McCarthy. Isn't that enough under 10J?
No, Your Honor. Officer Wisniewski's conduct would need to materially contribute to the collision. It is not here. At the end of the day,
In my mind, that hypothetical, they're both materially contributing, just to be clear. To me, they're both materially contributing, allegedly, based on the way it's pled, because one is going too fast, the other one is blowing through an intersection. They're both being negligent, and so aren't they both materially contributing?
no, Your Honor, I do not believe so.
How come?
Officer Wisniewski had only 0.4 seconds to apply his brakes. Had he even been driving at 30 miles an hour, an inference could be drawn that he still would have had a very short amount of time. There was nothing he could do to avoid this collision.
Oh, okay.
Furthermore, to the extent that plaintiff's claim is premised on a roadway defect, Chapter 84 is the exclusive remedy. Plaintiff cannot bring a separate claim under Chapter 258 for negligence, where his claim was originally caused by a roadway defect under Chapter 84.
Do you agree that if it was error to dismiss the plaintiff's claims against the officer in the town, it was also error to dismiss the cross claims by the Anders? So do they stand and fall together?
Well, Your Honor, although not raised in our papers, the town retained its sovereign immunity from claims of contribution because it is not contained in the definition of a person under the contribution statute. Were that not the case, yes, I would agree that it would have been error to dismiss those claims.
So the Commonwealth, or sorry, the town can't be liable for contribution because it's not a person?
Yes, Your Honor.
Is there any case law to back that up?
Your Honor, there is a plethora of case law addressing what is necessary to constitute a waiver of sovereign immunity. And that is an issue that we'd be happy to submit further briefing on if the court would like. If there are no further questions, we will rest on our papers and ask that this court affirm.
Seeing none, thank you all. We'll
Thank
take
you,
it
Your
under
Honor.
advisement. We're going to take a short break. Our next case is 25P 1407, Department and Children and Families versus Mother. Mr. Rosenthal.
Good morning, Your Honors. May it please the Court. Steve Rosenthal representing the appellant mother. We're asking that the Court vacate the lower court order granting the guardianship petition and remand the case for further proceedings. DCF, as the petitioner in this case, had the duty or the burden to prove that the grandmother who was proposed as the guardian, that appointment was in the child's best interests, and had to prove that by clear and convincing evidence.
Do you agree that, or what's your position on whether the mother is disputing her unfitness?
There's no question she did not concede her unfitness. You may be able to interpret her statement that she wasn't seeking custody as being an admission of unavailability, but I would direct the Court's attention to Care and Protection of Aaron, an SJC case, 443 Mass 567 at 572 and 73. A parent's stipulation that he or she is unavailable to parent a child is a valid basis for a judgment because it is an admission of unfitness. However, the factual basis for the initial determination of unfitness should appear somewhere in the record, either in a colloquy or a writing signed by the parties. And we don't have that in this case.
Wasn't she found unfit after trial?
I beg your pardon?
Wasn't she found unfit after trial?
Well, first of all,
did not
DCF
appeal.
wasn't asking for her to be found unfit, but putting that aside for a second, the judge's findings were inadequate because, number one, there were three prongs to the judge's decision, that she based it on mother's prior history, meaning history before 2022 when child was removed from her custody, and that was the first one. The second one was mother's inability to engage in services with the child, and three, the status of the relationship between the child and the mother. And the problem there is the first prong was stale. The second prong and the third had to do with the child's documented and repeated refusal to engage with the mother in services. Mother's not the one who abandoned the child in this case.
The child was afraid of the mother.
The child says, well, of course that's hearsay, but the child says that.
He can testify about what his feelings are.
My point is, Your Honor, that the child who at the time of trial was, 16 years old, going on 17, was, I'll blank it for a second.
I mean, she pled guilty to assault and battery and a dangerous weapon on the child that caused an injury.
She admitted to sufficient facts.
Yes.
She did not plead guilty, and she wasn't convicted. The case was continued without a finding, and she had probation assigned for a year, but she completed probation after 8 months. The mother had made tremendous improvements in the passage of time from when the child was first removed from her custody until the time of trial, some 3.5 years. And yes, the child, who is now 17, or who was going on 17, stated that he was afraid of mother, but that, based on the mother's progress, which the judge conceded, and the judge pointed out she'd made tremendous progress.
I think he feared her because of the progress she had made.
I beg your pardon?
He didn't fear her because of the progress she was making. He feared her because of their history.
But there was no continuing vitality of the type of parental deficiency that would justify.
Aren't those credibility determinations?
I would say in this case, as in any case where a parent's parental rights are at stake, could be modified, could be removed or terminated. The
Did she ever seek review and determination on the finding of unfitness?
Not until very recently, Your Honor, and in that case, the case was assigned so far down the road that she realized that a child would reach the age of majority before that case would ever be resolved.
So even if we were to assume that she's fit to parent the child, the judge still had to look at the best interest of the child, right?
Yes.
And mother was offering no alternative to the grandmother's nomination as guardian.
Well, Your Honor, I would direct your attention to adoption of DORA, and which says that neither Chapter 119, Section 26B, nor 210, Section 3 require that any party have proposed or supported the judge's ultimate custody order.
Well, the best interest issue is committed to the sound discretion of the judge, yes?
Yes, I agree.
And so the judge is presented with a circumstance where the grandmother, on the record, has been an excellent caretaker and guardian of the child, and mother nominates no one in the alternative, and the judge has to decide, should we go with no one or the grandmother who's taking care of the child?
Well, first
And
of
then
all,
you have to show how that is outside the range of reasonable alternatives.
well, to answer part of your statement there, the fact that the mother didn't set forth her own plan for the child doesn't mean that she was required to do so. And I refer you to adoption of Zarina, 93 Mass Appellate Court 800 at 804. And the adoption of Cadence doesn't say that mother is obligated to provide some alternative plan.
The mother is saying, I can't take the child back.
Then the judge has the authority to reject DCF's plan and propose her own plan, impose her own plan.
Right, but isn't it relevant to whether the judge abused his or her discretion that the judge is only given one option and that mother, the only party opposing it, is not proposing anything else? Isn't that relevant to whether the judge abused the discretion?
I would say it's relevant, but it doesn't carry substantial weight because the judge has the authority to tailor the remedy as he or she sees fit.
So what would have been a remedy here that was more within the judge's discretion than appointing the grandmother guardian?
Well, okay. To reject the guardianship petition and ask DCF to continue services and to provide a different alternative than the grandmother. There were statements that, yes, grandmother had been compliant and was involved in child's care. However, the facts of the case, the chronology, which I outlined on page 10 of my brief, shows that she wasn't very successful at it. And she, at the time of trial, she wasn't proposing that.
So the child had been placed with the grandmother for a couple of years at the time the guardianship was adjudicated. So are you saying that if custody were left with DCF without the grandmother being appointed guardian, wouldn't DCF have continued the placement with the grandmother, or are you saying that would have been an abuse of discretion
Well,
as well?
one advantage to continuing DCF custody would be that when the child turned 18, which will be in a few months now, DCF could continue to provide services to the child, whereas if the guardianship is granted, DCF is pretty much out of the picture. And that option, and I direct you to 110 CMR Section 23, a child has to be in DCF custody in order to be eligible for additional services.
Was that argued to the judge?
I beg your pardon?
Was that argued to the judge?
No, it was not.
I'm trying to understand. It sounds like you didn't quite answer Justice Sachs's question, but would DCF in that situation keep the child with the grandmother? Or if not, then, I mean, I don't know DCF's business. They know it better than I do. But finding a placement for like a foster placement for a 16-year-old kid seems like it's going to be really hard. In other words, is that a practical option is there a practical available option other than the grandmother?
Well, at the time of trial, mother was not seeking custody. However, if the child remained in custody, and if mother and the child continued to rehabilitate their relationship, and there was some evidence at the time of trial that that was occurring, then mother could have sought review and redetermination at that time.
But this all seems really important or relevant to the judge's discretion. If all this maybe, this, that, it seems like the judge, who knew a lot more about this than I do, would recognize this is an impossible, there's the alternatives here, there are no good alternatives here. And how can that be an abuse of discretion?
It's an abuse of discretion because the grandmother had been delinquent in her care of this child.
Right, but let's just assume for the sake of argument that grandmother is the best option. That let's accept that she's been less than optimal, but there's no better option. How is it an abuse of discretion to say we're going to stick with the best option, which, by the way, is what the kid wants? How is that an abuse of discretion?
It's an abuse of discretion because grandmother's care had contributed to the child's brushes with the law, obtaining a tattoo, obtaining or contracting a venereal disease at age 13, all of this while in grandmother's care. And at the time of trial, she would say, well, I know he skipped school because the school tells me. Did she say one word about what she does to encourage him to go to school? Yes, there was a finding of fact which said that, yes, she works with DCF. There was these were all conclusory statements. I pointed out findings of fact 19, 36 through 38. They were all drawn from the two exhibits that were presented in this entire trial. And my position here, mother's position, is that grandmother's benign neglect had led the child to a position where he was in court in several criminal cases. He I don't want to repeat myself. He got a tattoo.
Benign neglect caused harm to the child. That's your argument.
Yes. Well, let's say the shoe was on the other foot, and that all of this stuff happened while the child was in mother's care. I suspect that DCF would say that she was neglectful, and that might be justify removing the child from her care at that point. I think grandmother did not do her job in this case. She wasn't appropriate. She was not acting in the child's best interest by letting him pretty much run free range. So, if there are no further questions, then I will rest on my briefs.
Seeing none, thank you. Mr. Bayless.
May it please the Court, Jeremy Bayless for the Department of Children and Families. This is a case involving a troubled teenage child who had been physically assaulted by his mother and who, despite being out of her care, remained concerned and felt like he would not be safe around her. He was in the care of his grandmother, who was doing the best she could while helping this child deal with the trauma he had suffered and trying to find ways to address his concerning behaviors. She was working with the school, working with his IEP. She was working with the department to ensure that services got in the home. She was ensuring that he got to medical appointments that he needed to get to. And when he made poor decisions and ended up detained by DYS, she coordinated with, his release to get him back and get him on the right track. When he contracted venereal diseases, she took him to the doctor and she got him some education on how not to do that. She told him not to get a tattoo. He did that against her wish. I don't necessarily think that it is reasonable to consider a tattoo to be the sort of harm that leads to the removal of a child or the denial of a guardianship.
Unless he got hepatitis from that.
Well, true.
I
But,
don't know that he did. I'm not trying to make facts.
It could be, but we're limited to the facts that we have
Right,
here.
right.
You know, I have to disagree with my brother that I think that a parent in the same circumstances would have the department involved, because this is a proposed parent, proposed guardian, who's doing what she can in a difficult situation. That is different than a parent who is seeing a difficult situation and not acting.
Can I ask a question? Your opponent's brief, or the mother's brief anyway, asks for a secure facility. I was wondering, is that something that can, in this context, be ordered? I mean, I don't know what they meant, but obviously I'm thinking like a DYS facility. Is that an option?
Not at that hearing. There are certainly kids in DCF custody can end up in secured facilities, but I don't think that it would involve being placed there sua sponte by a judge in a guardianship proceeding.
Okay.
The options that were available were, the reasonable options that were available were either just no to the guardianship petition with instruction to the department to figure it out. To Justice Sachs's point, he would have just stayed with his grandmother. There was no abuse of discretion by the department placing him there, and there was no motion or argument to meet that standard to make him move. Or granting the guardianship, which would have kept him where he was, but would have did provide him with the permanency and the stability of knowing who his permanent family is, who his person is. And as we know from Nancy and innumerable other cases in the Commonwealth, part of the benefit of providing permanency is, emotional for the child. It's not just that they're not being physically moved around or that they're in a place where good things are happening to them. It's also that it removes the uncertainty that he's going to court, or he knows that court hearings are regularly happening, where he could be sent home to the woman who stabbed him in the head. And that is something that still traumatized him to date, and it was absolutely a contributing factor to the behaviors that mother seeks to lay at grandmother's feet. This is a child who deserved to have that stability and that safety, and the record is sufficient, and the judge did not err in providing it to him.
Could you address the mother's reliance on care protection of Aaron, the SJC decision that says, because the factual basis for the initial determination of unfitness ideally should appear somewhere in the record, either in a recorded colloquy or in a writing signed by the parties?
So the the mother was found unfit. That judgment was still good, and that judgment was acknowledged. The court had evidence that mother had assaulted the child. That was obviously not so stale as to be precluded from consideration. The court had evidence that since that time, the child, who was 16, all children's wishes are relevant, but that's old enough that it is not dispositive, but certainly very relevant, felt unsafe around him and felt safe where he was. And the evidence also contained that during the few times that mother interacted with child, the interactions were mostly criticism and argument, which is the same thing that led to the violent outburst.
But it seems to me that we're talking about Aaron because the mother at the guardianship hearing said, I can't take the child back.
Yes.
That's the analogy to the stipulation of unfitness at issue in Aaron.
Yes.
So does Aaron suggest that the mother's statement that she can't take the child back need to be formalized in some way?
I don't think it does, because I think this is a different circumstance than a formal stipulation. You shouldn't show up to trial and say, I'm stipulating to my unfitness. She already was unfit, and she was conceding in that point that she was not in a position to take the child back. And it is a little bit threading a needle, but it is different to affirmatively stipulate versus to just not argue something. And I think that's what the statement was. Their attorney was asked, is your client asking for custody? She said no. He said, I'm only here to argue against the wrong placement. Those two different parts of the transcript.
But if we were to affirm on the basis that she just wasn't available at the time of the guardianship appointment, and therefore, I mean, that's one of the predicates for appointing a guardian, if a parent is unfit or unavailable. If we affirmed based on that agreement that she couldn't take the child back, then you're saying that doesn't need to be formalized the way a stipulation of unfitness would be?
I don't believe that it would. And I also think that if it did, certainly this would not count as a full colloquy, but the court did inquire what he wanted on 3 different occasions, 2 occasions, asked what mother was seeking in the proceedings and was given unequivocal answers from counsel. So I think there's enough there. But I also think that this wasn't decided, as my brother correctly notes, it wasn't decided on a formal waiver. Rather, it was simply an argument that was not, it was a point that was not contested. It was already in place because mother had been found unfit. Mother wasn't seeking review of the decision finding her unfit, wasn't asking the court to do that.
Well, the department has to prove it.
Yes.
In a guardianship proceeding, right?
By clear
convincing evidence?
Yes, and the evidence supporting that was that she was found unfit and that her behavior since that time remained demonstrating the same concerns that, while she had not had the opportunity to assault the child again, the same sort of precursor behaviors were still there in her interactions, and the child was still acting out. I see my time is up. I'm happy to expound further, but otherwise I'll rest.
Seeing none, thank you.
Thank you.
Ms. O'Brien.
Good morning, Your Honors. Tamika O'Brien on behalf of the child. Your Honor, the child at the guardianship trial maintained that it was in his best interest and that it was in his wishes that he remain with grandmother. I don't have a whole lot to add here, but I can say that mother may not have been required to offer any alternative placements, but as Justice Wood mentioned, it's not particularly practical to remove a 16-year-old child who's lived with his grandmother for the past few years, 2 or 3 years, and put him in a group home. That's not practical at all, to remove him from that permanency and stability. So while mother may not have had an obligation to put forth an alternative placement, when the judge looks at this case, the judge looked at it correctly of where would we place this child? This child's not able to go home. Mother's not available for custody. He's at grandmother's house, and maybe grandmother's not the most perfect guardian, but she's doing the best she can, and this is where the child feels safe, and that is important here. The child will be 18 in October, and he made his wishes very clear on multiple times that he wanted to remain with grandmother.
I have a question about a citation at page 26 of your brief. It's to a case also cited by the mother, I think, guardianship of Salim. And on page 26, you say, in Salim, this court, or panel of this court, vacated a guardianship where the proposed guardian failed to provide structure or supervision and where the record affirmatively demonstrated that the guardian's conduct undermined the child's welfare. So I looked at Salim in the appendices or the addenda to the briefs, and it doesn't seem to say anything like that.
You are correct. I misread that case. And I did notice that after I filed the brief, and I probably should have filed a corrected brief. So I apologize for that.
Can you maybe write a letter in explaining how that happened?
Yes, absolutely.
Because I don't see anything in Salim that even suggests that, so it's a concern.
Thank you. Does the panel have any other questions?
Seeing none, thank you all.
Your Honors, the child requests that the judgment be upheld. Thank you.
Our last case is 25P47, Katsman versus Gobadi. Mr. Sayegh.
May it please the court, Raymond Sayegh on behalf of the appellants. This was a civil judgment that was procured by manipulation and trickery and cannot stand. This jury in this case did not have all of the information and did not get the complete case, and therefore we cannot rely on what the jury said. This jury was both uninformed and misinformed. A new trial is required in the interests of justice. The plaintiff's case in this matter involved the claim that he was an uneducated man and did not know what a short sale was and did not sign any of the application or other documents. Therefore, he relied exclusively on MITRA Gobadi, who was not his realtor, but someone that he knew. She happens to be a realtor. She was a facilitator in this case. He alleges that all of the signatures were a forgery.
We know what the allegations are, so why don't you get to why the jury was uninformed or misinformed?
Thank you.
You say uninformed, which suggests you're complaining about the exclusion of some evidence.
Yes, Your Honor.
I didn't see any claim to that effect
Well,
in your brief.
There were 4,000 pages of previously undisclosed discovery that was disclosed as they were impaneling the jury. This case was six.
And at some point, the judge said, okay, I understand there's some disputes over the admissibility of this. Why don't you two sit in together, and you can use my courtroom this afternoon if you want, narrow your differences, and come back to me with any issues tomorrow morning. And the only one who came back with issues was the plaintiff, suggesting that some of the documents that he had disclosed should not be admissible. And the judge resolved those disputes. But I don't see where you objected to the use of any of those documents, until, I guess, maybe your motion for new trial, which is kind of too late.
Your Honor, I submit, first of all, I was not trial counsel, but trial counsel did object to the documents, and his objections were overruled.
Where? I looked at the transcript at 604, 608, 632, 641. I couldn't find it.
Well, remember, Your Honor, the documents were not turned over until the 16th. He objected the next day.
Okay, what page?
I believe it's first is page They discussed it at page 70, only limited docs in the discovery. Once the trial began, page 70 of the January 16th binder. He discussed it there.
What page is that of the record appendix transcript record?
I'm sorry, Your Honor, I don't have that handy.
It's page 70 of which transcript? Which date?
January 16th, the day they were impaneling the jury.
But in your brief, I think at page 30, you say none of the, since the business certifications pursuant to 23378 were missing, none of these documents were admitted into evidence.
That's right.
So how, isn't that dispositive?
No, because his claim was he had never done this before. The documents actually had evidence of transactions, short sale transactions he had engaged in 2011, 2012, 2013. His signature was on those documents, and the judge allowed him to ask the plaintiff, but because there were no certifications, that ended the inquiry. So this jury was not informed about that that the plaintiff had engaged in short sale transactions, or at least gone through the process with other realtors besides and before this transaction. So it completely...
But in this case, your opponent will say you're mischaracterizing the fundamental claim here. The fundamental claim is not that he didn't know anything about short sales. The fundamental claim is this short sale, these defendants promised him 3 things, and you know the 3 things, and then did not deliver those 3 things. And so that's fraud and breach of contract, et cetera. And it has nothing to do with his knowledge. So how are you prejudiced given that that was what the actual allegation was?
His allegations was actually that I never signed anything, and I didn't know anything about this transaction at all, and I didn't know anything about short sale. I didn't know what that was.
Sir, I didn't know anything about this transaction. That wasn't his allegation. His allegation was I did know about the transaction. They promised me these things, and then they didn't give me these
He
things.
said both, Your Honor. I submit that the transcript submits both.
Okay.
He said both. I
Okay.
didn't know anything about this, and then he said, I didn't sign those documents, it's not my signature. But he also
What do you mean in the 4,000 pages? Is that what you're talking about?
Sorry?
Are you talking about in this case?
In this case.
Right, okay.
Yeah.
Okay.
In the prior document, about a half a binder's worth of documents about he and my client testified a little bit about it, that he had pulled out in a prior transaction.
Did you use those documents in your defense?
I'm sorry?
Did you use the documents in
Your
your
Honor,
defense?
trial counsel was not allowed to because he asked the plaintiff, isn't that your signature? Once he denied it, then the judge said, you can't go any further. That's it. So on top of not getting the documents in a timely fashion to conduct the discovery on his own, he was not able to even ask and go any further.
I guess this goes back to, I had the same question that Justice Sachs had, and you were given, or trial counsel was given the opportunity to sit down with plaintiff's counsel and go through these documents. And were any objections made by defense as a result of that meeting, if it occurred?
Yes, there were objections, and that's what I was referring to. I thought I answered that for Justice Sachs, and I apologize if that wasn't clear. He did bring it up. He was overruled.
Did he ever seek more time to investigate the documents?
I did not see that in the record, Your Honor. I just saw that he repeatedly objected both to the documents and to Mr. Crease, and his objections were overruled by the trial judge. Now, the documents, Your Honor, if there were witnesses that realtors who could have come in and testified, the process that they went through in 11, 12, and 13 with Mr. St. Louis, that would have completely undermined his case, I suggest, and made his case far less palatable. The second, Your Honor, issue is the issue about Darrell Crease. Darrell Crease.
I didn't see an objection to Mr. Crease
I'm sorry?
either. I didn't see an objection to his testimony. I saw a request for voir dire, which was denied, and then nothing further.
There is an objection in there as well. He did
Where is
object, when they first raised that he was a rebuttal witness, he objected that he wasn't disclosed prior to trial, and he was not an appropriate rebuttal witness.
Where is that objection raised?
That's later on in the trial, Your Honor. At the time,
Not at the time he testified?
I'm sorry?
It was after he testified?
No. After the plaintiff rested, they indicated that
You're going to have to stand at the podium, sir, or the microphone's not going to pick it up.
I'm sorry?
You won't be recorded if you're not standing at the podium.
I'd have to find the page, Your Honor.
You can bring it over to the podium.
I'm sorry?
You can bring your binder to the podium.
This was during the trial when it was announced that Mr. I can't put my hands on that right now, if I can just have a minute.
Can I ask you a question about the damages? Suppose we agree with you that the damages were excessive because the jury relied on the valuation at the time of trial rather than at the time of the short sale and the very closely thereafter sale to someone else. So what's the remedy for that? Is it a new trial? Do we send it back to the trial judge to say, to determine whether a remitter is appropriate? In other words, give the plaintiff the option of accepting a remitter or else getting a new trial? I mean, we can't resolve ourselves what the proper damages are on this record, can we?
I don't think you can. I think that the first three issues go to an issue whether a new trial. The damages, I agree, were also wrong because this is 9 years later.
I understand your argument that they're wrong,
And I think
but if we agree with you, what do we do?
I think that you need expert testimony with regard to the condition of the property at the time, what it took to put the house in the condition it was in based on the city's assessment, and what was the value of the house at the time, as Your Honor said, at the time the house was resold. Because I think
But if we agree with you that that's the correct theory, what's the remedy here? Do we order a new trial? Do we order the judge to consider a remitter or else a new trial? Or do we do we reduce the amount of the damages judgment ourselves?
I don't think you have the information to be able to for you to set the amount. I think that it would be remanded. Again, I'm not waiving the first arguments, but understanding where you're going, I think that the correct remedy on, if that's the only issue, would be it's remanded back to the court to conduct further hearings consistent with the rulings of this court. And that would be to correctly assess what the value of the property was so that the appropriate amount of damages could be awarded. Very different than 9 years later.
Okay, but procedurally, what's the right way to do that? Should the judge have granted the motion for a remitter or a new trial? In other words, if your argument after trial it was, and I think it was, that the damages were excessive and should be reduced, then does the judge have the power to just reduce them like that and that's the end of it? Or does the judge have to reduce them and offer a remitter as an alternative to a new trial?
I think the
plaintiff the choice.
May I reply? Your Honor, I think it's appropriate that the issue of damages is not something that the judge had within his own knowledge, and therefore it would require testimony and data before the court to reach the right number. Unless...
all the testimony is there. The judge heard it. Judges have to do this all the time when a remitter is sought, don't they? They have to determine not necessarily what the precise correct amount of damages is, but I think as you may have said in your post-trial motion, they need to find somewhere that's in the reasonable range.
Well, they could do that if they looked at the value of the house, what it was sold for, when it was sold in, I think if I remember right, the dates were, the sale was in March, the house was resold in June. In between, you had the loans that were taken on the house and the judge could do that.
There are a lot of moving parts for the judge to look at in figuring out a number, I suppose.
Right.
But do you have some authority that says that that would be the way to do it rather than the remanding to the judge just to reduce the judgment?
Again, I believe I cited some case law in the damages section, which is the argument at the end that talked about the correct, give me 1 second.
Well, we can certainly look at your brief, but I didn't see anything there that prescribes the procedure. So if you do have something, maybe you can send it in.
I would say the Barshak case also talks about the difference between the property value and what the defendant had paid.
Yeah, that's the measure of damages, but that's not quite
But not
answering my
quite
question.
how you go about it. On the Darrell Crease, if I may just briefly in the time that I have left, Mr. Crease admitted that he had no personal knowledge. The judge admitted, cautioned plaintiff's counsel and plaintiff that Mr. Crease could only testify on personal knowledge, that which he heard and saw.
But what he testified about was his prior interactions with the defendant, and it seemed relevant, given her testimony, that her original plan was to let the plaintiff live in the house, get it renovated, and live in the house rent-free. In fact, Mr. Crease's testimony suggested that was never the plan. The plan was consistent with what she always did, which is to flip these things quickly. And that seems relevant.
But Mr. Crease did not have personal knowledge beyond the first meeting in 2011. What transpired between these parties in the 4 years thereafter?
I thought that he testified that he had done seven transactions with her, and that that was her MO.
Again, not this transaction.
Right.
So that becomes character evidence and a smear against her.
Okay.
All right. Thank
Which
you.
is exactly what the court said they weren't going to be allowed to do. Thank you for your time.
Ms. Bluford.
Get out of your way.
Good afternoon. I think it's afternoon. May it please the court, Attorney Nicole Bluford for the late Christopher St. Louis, who had passed away. Stepping in his shoes now is Jackie Katzman, the personal representative of the estate. I have to highly disagree with my brother here that this case is about manipulation in the jury being uninformed here. I just think respectfully the defense just didn't present their case very well. So let me just jump right into it. Let's start with the production of the 4,000 pages that they claim. And just so the court is aware, I am the counsel that handled the case. I was the only counsel that handled the matter. So I would agree if 4,000 pages were presented to any lawyer on the day of trial, that would be unfair. And even beyond that, even if the judge said, well, let's cure it by, you using the courtroom to go through documents, et cetera, that would be enough. However, what my brother in his brief and his oral argument today didn't present to the court, the arguments that were made by myself at that time that the court very well took into consideration in their curing of the matter. This was no way, shape, or form late production of documents. And I'm sure that the court had probably saw in our response to the opposition of the motion for the new trial, that in fact, it was produced in 2019, it was produced in 2020, the same documents, it was produced in 2023, and in fact, in 2023, we were, in regards to a decision made by the court, I had to email the clerk of the court with all documents pursuant that we were going to be using at this trial. So to say that they're receiving those documents, right before trial is not the case.
Well, we can't resolve the factual issue, and we don't have the 4,000 documents to go through one by one to make sure when and whether they were produced. But do you agree that the documents were objected to on the basis of late production?
He did not object to it, and that's why he could not point it out here in the transcript. However, did he raise the issue of the fact that, he needs more time to go through it? Yes, he did. And as Your Honors had pointed out, at the conclusion of the meeting, I'm the only one that came back with issues in regards to the documents that were produced. I think there are multiple ways that, a defense counsel, if he feels that he's getting documents late in the stage game,
I thought he did not ask for more time.
No, he did not. I'm saying he could have asked for more time. He could have asked for a continuance. He didn't do any of those things. And I think that would have been the proper objection. Just him raising the issue prior to the start of the trial, me making those arguments, well, the judge is saying, hey, this is the way I can cure it based on the arguments made by both parties. He came back and moved forward with the trial. That was on him to move forward, and we did so. I also want to raise another point. He makes an issue of the documents of the 4,000 pages, but yet it was trying to admit the documents that we had produced. So it's either one or the other argument.
Can I switch you to a different topic?
Yes.
Which is the evidence that Mr. Fitzgerald was involved in any way in this alleged
conspiracy.
fraudulent scheme.
Yeah.
Right. I mean, it seems to me that they were married, and he handled some of the paperwork, and he was, I guess, signing things on behalf of the LLC. But there's no evidence that he ever spoke to Mr. St. Louis. There's no evidence about internal communications between him and his wife, Ms. Gobadi, not surprisingly. What is the evidence that he knew of any fraudulent scheme?
Case law doesn't necessarily require the evidence of the interaction, if that's what you're getting at, between Mr. Christopher St. Louis and Mr. Fitzgerald. Just the fact that he had conscious knowledge of the fraud or knew that
he had conscious knowledge, or even that he was willfully disregarding it.
I think it's important, as you mentioned, they are married. Mitra Gobadi, separate of that, is a representative of him. I think it's also, when I say representative, as acted as a broker, representative on his behalf, and it's very clear that they worked together in past transactions. So to not think that they had any communications with each other, I think he was very knowledgeable. I would also...
Sorry, but if she, again, specifically, there's these 3 promises. What's the evidence that he knew these 3 promises had been made, the details of the deal? In other words, I can understand an inference that, okay, Gobadi says, we're buying this house, Mr. St. Louis's house. Okay, we're doing a short sale situation. We've done that before. Okay, we're doing that. He's involved in buying the house. But what's the evidence that he knew the specific deal she had worked out, which was the basis for these allegations of fraud and breach of contract?
I would argue the fact that in order for a buyer, broker, agent, whatever you want to call it, to enter into a transaction, they can't do it without giving you the information. So oftentimes, homeowners or sellers or buyers in transactions, right? We have this middle piece, the realtor, that makes representations based on, what we say, and then they come back to us and tell us what is a part of the deal in the negotiations. So I'm saying that essentially she was an agent of him, and he could not get into this deal without communications from her, and based on her communications from her, they together conspired in this fraud, if that's making sense. So it can't be just she have knowledge of one thing and he have knowledge of the other. She would need to represent whatever was told to her comes back to you.
Maybe if she's staying within the scope of what you are calling an agency agreement, but sometimes agents go outside the scope of their authority.
Did
he authorize him to make false representations to her to induce, did he authorize Ms. Gobadi to make false representations to the plaintiff to induce him to enter into this agreement?
I think we have some knowledge of Mr. Fitzgerald knowing about this by way of the fact that there was already a signed deed signed on the day of the closing transaction. I don't know if hopefully the court caught that, and I think that was...
Something about the date of a notarization, which
the date of the notarization, and I think that was mind-blowing to the jury. If you're making these promises that you are going to live in this house indefinitely, and that all you need to do is essentially do these renovations, how is it on the same day of the sale, the deed, which was subsequently recorded in June, notarized in March, the same exact date? And on cross-examination on Ms. Gobadi, it was a mistake. Sorry.
Right, that's what I was going to say. I think Ms. Gobadi was the one who was questioned about that. But the question here is, what did Mr. Fitzgerald know? I think that there's ample evidence. Ms. Gobadi admitted to a lot of this in testimony. But the question is, I keep having anyway, is what's the evidence that Mr. Fitzgerald knew about any of the material elements of the fraud? And I'm not seeing any.
I guess there's nothing directly, because there was never a conversation. There's no documentary evidence here. But again, I go to the common practice that when people enter into transactions, I'm talking buyers and sellers, they often don't interact with each other. They don't, and that's why you have realtors. And the realtors are a mouthpiece for you. They don't know knowledge about your house. They don't know about conditions. They go off of you, the homeowner, and they make those representations and vice versa. So I think oftentimes they're congruent in the knowledge that they know. I also wanted to take a moment to state this. Also furthering his knowledge of it is the fact that he had interactions later after they closed in regards to the work that was being performed in the renovations, which was consistent with what Ms. Gobadi had testified to.
Can you point me to where in exhibits volume, this notarization dated on the date of the original transaction appears?
On the, in the exhibits, you're saying?
Yes. I didn't see it cited in your brief, and I couldn't find it.
You know, I don't have that handy. I can represent as an officer to the court that was introduced to the court, because, and again, it was on cross-examination. I asked her about it. She did not deny it. It was a mistake. I don't know how she could testify it was a mistake about what a notary did, but then it was recorded in June. And that's nothing but being strategic. Why notarize something in March and record it in
quitclaim deed? Is that what we're talking about, the quitclaim deed?
The quitclaim deed that was subsequently
I'm just asking if it is. I don't mean to change the subject. Is that not what we're talking about?
We are talking about the quitclaim deed that went to Oz 14, I think, LLC.
I think it's Exhibit 45. I think it's RA 2, page 243 and 244, I think.
Thank you, Your Honor.
Can we get to the issue of the damages? If the judge made a mistake in denying a reduction in the damages because of the reliance on the value at time of trial rather than at the time of the sale by the defendants to the Oz Realty organization, if he made a mistake, then what, and I know you say that he didn't.
Right.
That's a given. But assume he did, what's the remedy for us?
If he made a mistake, which I'm not saying he didn't, I'm hard to answer that question because it was already, looked at. And although I don't necessarily agree with what he did with reducing the award, he did. And at that point, I do argue that it's fair. So if he already looked at this and felt as though that the evidence that was produced at that point in time, because I would say, unless you're doing a retrial of this whole thing, where everybody's producing evidence, which I don't think the court's getting to, he's going to be limited to what he has. And what does he have? He has the testimony of Christopher St. Louis that, testified to what he felt his evaluation was. Now, obviously, he was cross-examined, and that cross-examination was in front of the jury. And
I guess the question is more procedural. It's assuming that the judge decided the damages incorrectly. Procedurally, if we were to send it back because of that, how would it take shape procedurally?
I'm not often lost for words, but on this one, I do not know, honestly, what the procedure would be.
It's always ask the hardest question.
Yeah, that one I don't have an answer for.
Do you agree? How could the value at the time of trial be relevant to the damages on the theories on which the jury ruled for you?
Well, breach of contract, fraud in the inducement, among some other claims. I don't think it can just be, it can go to the time of the valuation at the time of trial, because I do think it includes all of the value that he lost all that time. We know when this claim was filed, well, the closing was 2015.
But the breach of contract theory that you succeeded on was not that there was a contract to reconvey the property to Mr. St. Louis.
Correct.
It was the contract about you can live there for $2,000 rent and we'll pay your tax lien. So you can't get expectation damages for a breach of a promise to reconvey the property where that was never, the jury didn't decide that theory.
I understand the point. But what we were successful on is the fraud and the inducement, that he would not have entered into this transaction but for what those promises were. So it's essentially putting Mr. St. Louis back into the position he would have been had he not sold the home. So if we go to the sale, I think you're limiting him and you're not making him whole, if you're understanding my argument. We're putting him back into the position had he would have been had he not sold, because I think it was very clear from Jackie Katzman, it was clear from Darrell Crease, that he would not have sold that property. He was not interested in selling the property. He was told he was going to get it back. And again, I know that is a separate point, but the goal is to put the plaintiff back in the position he would have been. And if we do anything short of the evaluation, you're not getting justice for my client. If Your Honors don't have any further questions, I'm going to rest on my brief.
And thank you both. Well,
Thank you so much for your time.
with that, I'll bring to close today's session. I'd like to thank my panel, our law clerks, our court officers, our court clerk staff, our excellent timekeeper, and we'll stand in recess.